Ever wondered if 280 characters can defame you? Well, recently, the Delhi High Court weighed in on this. The court dismissed a defamation suit filed by Addictive Learning Technology Limited, an online legal education platform, against four individuals over allegedly defamatory tweets in a conversation thread on X, formerly known as Twitter. The company, which owns brands like LawSeco, Skill Arbitrage, and Data is Good, had taken legal action, but the court didn't find enough merit in their claim. So let's take a look at their arguments. The dispute began when the plaintiffs criticized national law universities, also known as NLUs, and their graduates, prompting responses in the form of tweets from NLU alumni, including the defendants. Essentially, they argued that tweets were harmful, derogatory, and damaging to their reputation, financial stability, and stock value on the National Stock Exchange. They also claimed that the defendants' actions spread false information, eroding investor trust and undermining the integrity of the stock market. They sought a permanent injunction restraining defendants from posting defamatory content on any platform, as well as from contacting them directly or indirectly. They also demanded damages for defamation in cyberspaces, asserting that defendants' unethical behavior negatively impacted investors who rely on accurate information for decision making, further harming the financial system's credibility. The defendants, on the other hand, argued that the tweet was an honest opinion, protected under the fair comment exception to defamation. They also contended that plaintiff's original tweet was provocative and intended to elicit responses, as we all know, a fairly common practice on social media. Interestingly, the defendants also argued that the plaintiff had a history of frequently suing people who posted negative reviews about its courses. In response, the plaintiff admitted to having filed multiple injunction suits in the past and even submitted a note listing six previous cases against individuals, including clients, accused of posting defamatory or misleading reviews online. This defense aims to argue that the lawsuit is essentially a SLAP suit. SLAP, also known as Strategic Lawsuit Against Public Participation, is a legal tactic that stifles public debate rather than addressing genuine harm. By pointing out that plaintiff's history of suing critics over negative reviews, the defense suggested that the litigation is part of a broader pattern of using legal intimidation to silence dissent. SLAP suits are designed to drain resources and wear people down, often involving massive damage claims and allegations meant to intimidate, harass, and overwhelm. These lawsuits have a chilling effect on free speech and public participation, essentially forcing people to censor themselves out of fear of legal trouble. Let's start with understanding what exactly is defamation. Section 499 of the Indian Penal Code defines defamation, and the new Bharatiya Nyaya Samhita carries forward this definition without any changes under Section 356. In simple terms, the law states that anyone who, through spoken or written words, signs, or visual representations, makes or shares a statement about someone with the intention or reasonable belief that it will harm their reputation is considered to have defamed that person unless it falls under specific exceptions. In the case of Rohini Singh versus State of Gujarat, the court ruled that anyone alleging defamation must prove that the defendant intended for the defamatory content to be seen or heard by an audience. But what exactly is a reputation, and can you really quantify it? The idea of reputation is somewhat vague, perhaps even dangerously so, since authorities can use it as a reason to restrict human rights. However, some believe that linking reputation to human dignity provides a fairer and more balanced approach. In 2017, a private member's bill was also introduced in the Lok Sabha to decriminalize defamation, but it didn't pass. In a landmark 2016 ruling, the Supreme Court upheld criminal defamation, saying that it's not an unfair restriction on free speech because protecting someone's reputation is both a fundamental and a human right. But the court also made it clear that reputation can't come before dignity. In a different case involving both sexual harassment and defamation, the Delhi High Court acquitted journalist Priya Ramani in the suit filed by former Union Minister M.J. Akbar. The court emphasized that protecting someone's reputation shouldn't come at the cost of someone else's dignity and backed the defense of truth in public interest. However, it's tricky to separate public interest from what just grabs public attention. They are not always the same thing. Just because something grabs attention doesn't mean it truly serves public interest. Coming back to the recent case, the plaintiffs based their defamation claims on rulings mainly revolved around news organization. But the court rejected this argument, pointing out that alleged defamatory statements were made on a conversational social media platform. It stressed that strict defamation rules that apply to newspapers and magazines don't necessarily work the same way for social media, which is much more dynamic and interactive. The court explained that readers generally take print media seriously, relying on newspapers and magazines for information that helps shape their opinions. Social media, on the other hand, especially platforms like X, is seen as a more casual space, not necessarily a reliable or verified source of facts. The court put it bluntly: if you post something on social media, you're going to get either praise or criticism, and you need to have broad shoulders to handle it. It also pointed to the sixth exception under defamation law, which backs this up. A person who makes a speech in public submits that speech to the judgment of the public. The court also questioned the plaintiffs for skipping the grievance redressal mechanism under the IT Act. Under the 2021 IT rules, social media users can file complaints about defamatory or abusive content through a platform appointed grievance officer with an option to appeal to a government run grievance committee. Despite this clear time bound process, the plaintiffs skipped it entirely and went straight to court in July 2024 without asking for a permanent injunction to remove the content. The court pointed this out, noting that they hadn't approached X's grievance officer to request the takedown of the tweets in question. This raised a key question. If they truly believed the tweets damaged their reputation, why didn't they use the official process designed for this situation? In the case of Niti Bhatnagar versus Citibank, the Delhi High Court made it clear that just feeling hurt or annoyed by someone's words isn't enough to sue for defamation. The defendants argued that the plaintiff's business regularly gets negative reviews but then hides them from the public, suggesting a deliberate attempt to cover up customer dissatisfaction. But the court wasn't convinced. It stated that even if the tweet in question contained false or malicious statements, that alone didn't legally harm the plaintiffs in a way that warranted action. The Delhi High Court had a similar take in another case, stating that no legal action can be taken for mere vulgar abuse or words that don't cause substantial harm. Simply put, just feeling insulted or offended isn't enough to take someone to court. This isn't the first time courts have had to navigate the tricky intersection of defamation laws and social media. Take Chadha versus State, for example. Back when Arun Jaitley was India's finance minister, he filed a criminal defamation case against opposition leader Raghav Chadha over tweets accusing him of corruption. Chadda tried to get the summons quashed, arguing that online statements should be handled under the IT Act rather than traditional defamation laws. But the Delhi court didn't agree. It upheld the use of criminal defamation laws for online content and made an important clarification. Tweets could count as republication, meaning the person sharing the content could also be held liable. The key factors dictating this would be context, intent, and impact. The court explained that simply sharing a post without endorsement might not always lead to legal trouble. But if a retweet amplifies or approves a defamatory statement, it could be considered actionable. As court continue to sculpt the rules around online defamation, one thing remains clear. Engaging in online discussions carry both accountability and consequences. That's all for today. This is Sakshi with MediaNama. Please subscribe to MediaNama for more tech policy updates. Thank you.